With one of its elections petitions already dismissed by Chief Justice Acting Roxanne George, the second petition, 88P, filed by the APNU+AFC Coalition, will move forward in the High Court at a hearing set for April 7. But even ahead of that hearing before the Chief Justice, Attorney General and Minister of Legal Affairs Anil Nandlall has questioned the success of that petition filed by Claudette Throne and Heston Boswick. The AG insists that just as the first petition, 99P, was dismissed, this petition, although not found wanting on the grounds of procedural compliance for service, is also destined to fail. In his written submission to the court, the Attorney General explained his position, reasoning that no evidence has been put forward by the filing attorneys representing the APNU+AFC Coalition to invalidate the results of the March 2, 2020 general and regional elections. According to the Attorney General, in his submissions, the petitioners have failed to discharge the heavy burden of rebutting the constitutionality of Section 22 of the Elections Law Amendment Act, as they have submitted in their written submissions. The Attorney General said neither have they been able to establish that Order No. 60 of 2020 was in any manner whatsoever unlawful, as they so claim. In their written submissions, the petitioners have challenged that Section 22 of the Elections Law Amendment Act is unconstitutional and Order No. 60 of 2020 is invalid, null void, and of no effect. Section 22 of the Elections Law Amendment Act serves to resolve irregularities, discrepancies, and anomalies occurring in the elections process and to determine a final credible count. The Attorney General intends to argue orally on Wednesday that the coalition must not only establish that the election activities were unlawful, but that it has or may have affected the results of the elections. Firstly, it is already submitted that Order 60 and the recount process are valid and lawful. Secondly, this petition fails to establish any satisfactory evidence that the said Order 60 and the recount process have affected or may have affected the results of the election, the Attorney General submitted. Nandlall concluded in his 22-page submission that there is no evidence of any variation between the first count, which took place at the end of poll, and the count which took place under Order 60. Even if it is found that the recount and Order 60 are unlawful, there is still no evidence that either both of them materially affected the results of the elections. This petition is destined to fail, he added. Meanwhile, the petitioners in Petition 99P have appealed its dismissal, asking the Court of Appeal to set aside the ruling of the Chief Justice. Nandlall has also argued that the appeal will fail. On January 18, 2021, Justice George reasoned that because former President David Granger was not served within the required 5-day timeline for doing so, and he has been found to be a necessary party in the proceedings, Petition 99P was declared a nullity and dismissed.